Ding, 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 ding. This is a big deal, everyone. You still have a claim under Section 512F in small claims court. This should mean that YouTubers who are getting these weird copyright claims, manual claims, automatic claims that obviously aren't accounting for fair use, you can use this system too. You might want to give this legitimate consideration whether you support the Case Act's passage or not, because small claimants, like individual YouTube creators who don't normally want to go to court because court can cost thousands of dollars, can either defend themselves with a 512F claim, or they can use the system to go after the claimant.
This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below.
So what is the Case Act? This is the latest copyright kerfuffle. This is the latest copyright legislation, and you're going to see articles from all of the copyright or small creator or consumer advocates, like the Electronic Frontier Foundation and some of the public service organizations are all going to be up in arms. And I'm not saying that they're wrong. We're going to see if they're right or wrong about whether a small claims court just for copyright is a good thing, a bad thing. We could have a little angel over here and a little devil over here, because you might see the copyright plaintiffs that I talk about on this show, and you might get the impression that copyright plaintiffs could abuse the copyright law because of some loopholes: access to justice, cost of an attorney, no free attorneys in civil court, very little in the way of public service organizations like the ACLU or EFF that would be able to defend even normal copyright disputes. It's not that they're not great organizations, but they're looking for clear cases where they can win and make progress for their cause. They're a bit interested in advocating for a particular outcome. And that's not bad. That's lobbying. You're allowed to do that. But we need to know that the EFF is also not going to be advocating for the Motion Picture Association of America or the Recording Industry Association of America. I mentioned some of these things about the copyrights for the little guy and all that at a copyright conference that was being held in Manhattan and it was with MPAA representatives and RIAA representatives, and even Larry, what's-his-face from Redigi was there before he got his appellate court ruling saying that you can't resell digital goods. You can't resell in abeyance or in violation of someone's license agreement. And the RIAA representative was appalled that I had these notions of copyright that we, maybe should go a little easier on the infringer because the penalties are so high that they don't act as much of a deterrent as it sounds like. Well, anyway, to make even more of a problem for copyright pirates or infringers, and then I guess to create more work for the defense bar and the plaintiffs bar, senators have introduced the Case Act of 2019. This is Bill S-1273, and there's a large number of sponsors. It's more or less a bipartisan bill. I don't mean that it has wide bipartisan support. It just rather has a good number of Democratic senators and a good number of Republican senators sponsoring it. And we're going to see what it creates today. I can tell you that it creates I just noticed something. I'll explain in a moment. This bill creates a copyright small claims court for claims up to, I believe, $30,000. So you don't have to go into federal civil copyright court and advocate for your copyright there. You can do it in a small claims court that is much more experienced, it will be, over its, as soon as it starts its lifetime and all that, if this passes. Now, the thing that I noticed that's concerning here, I was going to tell you that this had a prognosis of 23%, according to Scopus Labs, of being enacted. And the thing that concerned me is that yesterday it had a 4% chance. And now it's been updated to a 23% chance after it passes the Senate Judiciary Committee. So the bill was marked up by the Senate Judiciary Committee, and it will now be presented to the Senate for consideration for final vote. That doesn't mean it gets a final vote. That means it gets considered to be then put up for a final vote. So it's still possible that a senator could prevent the bill from being brought up. We know that certain Kentucky senators can block certain bills from being brought up. This may happen there. I'm really not a scholar of how this process works. I know a little bit about it. Tried to study it a few times, but it's kind of complicated, and but we can all learn together. So this bill was introduced on May 1st, 2019. It was considered July 11th. It was marked up July 18th and ordered reported to the full Senate. If the bill has further action, it will be reported here. So let's take a look at the bill. It is rather long, so we're probably going to be skimming through this. And remember, this isn't necessarily the final text of the bill, but it could be. It could be passed as written, so we have to be careful. So let's see, they're going to go through definitions first. A claimant is a real party in interest that commences a proceeding before the Copyright Claims Board. So we already know they're going to be creating a Copyright Claims Board and that a claimant can bring some kind of claim pursuant to a permissible claim of copyright infringement brought under Section 1504, which I don't think we've seen what that is yet. That's coming up here. Or non-infringement under 1504C2 or misrepresentation under 1504C3. So wait a second, let's back up here. If anybody was concerned, maybe this alleviates some concern. I already see that there's going to be a small claims for misrepresentations. That means people who have received false, fraudulent, or simply raw, incorrect, what do they refer to it as? Mistake or misidentification of infringing material. Maybe you can bring a claim for misrepresentation under 1504C3. Let's keep reading. A counterclaimant, of course, is a counterclaim and is a real party in interest. A person who asserts a permissible counterclaim under 1504C4. So this 1504 is looking important. The term respondent means any person against whom a proceeding is brought under 1506. Pursuant to copyright infringement brought under 1504, C1, C2, C3. Okay, so first we establish a Copyright Claims Board, 3 full-time Copyright Claims Officers to serve on the Copyright Claims Board. I would like to nominate myself to serve on this Copyright Claims Board. Could I be a member of the Copyright Claims Board, please? I promise I'll be fair. The officers shall be appointed by the Librarian of Congress to such positions after consultation with the Register of Copyrights. Copyright Claims Attorneys, we shall hire not fewer than 2 full-time copyright claims attorneys to assist with the administration of the board. I nominate myself. I think that would be a really fun job to have. Let's see. The officers have to be an attorney with not fewer than 7 years of legal experience. So far, so good. 2 of the copyright claims officers shall have substantial experience in the evaluation, litigation, or adjudication of copyright infringement claims and have represented or presided over a variety of copyright interests, including those of both owners and users of copyrighted works. Yeah, it sounds like I qualify. This is pretty cool. I would like to apply. Alternative dispute resolution. The officers not described in Clause 2 shall have substantial familiarity with copyright law and experience, etc. Other claims attorneys shall have 3 years of substantial experience, and there are senior level employees. Pay range is defined by the federal government. It'd be nice to have a federal government job for 10 years and pay off my student loans and still do lawful masses. In general, subject to paragraph B, the copyright officer shall serve for 6 years. There's a couple that serve for 4 years, 5 years, or 6 years, based on, I guess, what type of officer you are, and then how they handle vacancies, which all this is super interesting, but we really want to get to, 1503 and 1504. So the Copyright Claims Board has the authority to render determinations of civil copyright claims, counterclaims, and defenses that might be brought before the officers under this chapter to ensure that claims, counterclaims, and defenses are properly asserted and otherwise appropriately brought, to manage the proceedings, to request participants and non-participants to produce information and documents relevant to the resolution of a claim, counterclaim, or defense, to conduct hearings and conferences, which should mean within the meanings of due process under the 5th Amendment and 14th Amendment, to facilitate settlement of the parties' claims and counterclaims, to award monetary relief under 1504E2. So we really got to get to this 1504 section, to provide information to the public concerning the procedures and requirements, to maintain records, to carry out other duties necessary as set forth in this chapter, and when not engaged, to perform duties as may be assigned by the Registry of Copyrights. And then the attorneys provide the administration and procedures and information, including about subpoenas for 512H, by the way, that's in here, to provide information to potential claimants about bringing a 512H subpoena matter to identify an alleged infringer. I don't have tally lights on, that's what I should do. When not engaged in performing their duties, the attorneys also perform such duties as assigned by the Registry of Copyrights. Independence of determinations. The Copyright Claims Board shall register the terminations in individual proceedings independently on the basis of the records in the proceedings before it and in accordance with the provisions of this title. The claims officers and attorneys may consult with the Registry of Copyrights, and subject to section 106X, which X might mean it's not defined yet, may not consult with the Registry of Copyrights with respect to the facts of a particular matter or the application of the law to the facts. And there are performance appraisals and directions by the registrar. They can't do anything inconsistent with the law. They may recuse themselves. Any party shall refrain from ex parte communications, and actions of the copyright claims officers and copyrights under this chapter are subject to judicial review as provided under 1508C. So we also want to keep in mind that we need to know 1508C. All right, here we are, finally, to the nature of the proceedings. Voluntary participation is the very first section here. Participation in the proceedings shall be voluntary, and any party to instead pursue a claim, counterclaim, or defense in a district court shall be preserved. So it is a voluntary thing. Everyone will have the opportunity to say, if you don't want to participate in copyright small claims court, you don't have to. So even if you are a defendant receiving a claim in copyright small claims court, you apparently have the right, if this passes unaltered, you would have the right to say, I want to have this in real court instead of small claims court. So if you don't trust the system to handle it in small claims court, you would be able to go straight to big boy court. Any proceeding before the Copyright Claims Board must be commenced within 3 years, which is the standard statute of limitations for copyright. And subject to section 1507, a proceeding commenced shall toll the time period under section 507B for the commencement of an action. So it sort of, we talked about that relation back thing. This tolls that time period, or this pauses that time period, and it acts in sort of as accordance with that time period. So what claims can be brought? Permissible claims, counterclaims, and defenses. They may render determinations with respect to the following claims, subject to limitations and requirements, and including with respect to particular classes of work. A claim for infringement of an exclusive right under section 106 by the legal or beneficial owner of the exclusive right at the time of the infringement, for which the claimant seeks damages within the limitations set forth in E1, which I guess is below. I guess that's below. A claim for a declaration of non-infringement of an exclusive right in a copyrighted work. You saw that in the Nike case, they needed a declaration of non-infringement because Kawhi Leonard had accused them of copyright infringement. A claim under 512F for a misrepresentation. Ding, 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 ding. This is a big deal, everyone. You still have a claim under section 512F in small claims court. This should mean that YouTubers who are getting these weird copyright claims, manual claims, automatic claims that obviously aren't accounting for fair use, you can use this system too. This is very important. Seriously, you might want to give this legitimate consideration whether you support the Case Act's passage or not, because small claimants, like individual YouTube creators who don't normally want to go to court because court can cost thousands of dollars, can either defend themselves with a 512F claim, or they can use the system to go after the claimant. And we'll see, maybe this is easier to do than filing a thing in federal court. Maybe I don't have to charge you as much money, and then maybe you can go to court for a couple $100s instead of a couple $1,000s. Wouldn't that be nice? So a claim arising under Section 512F for misrepresentation in connection with a notification of claimed infringement or a counter-notification seeking to replace removed or disabled material, except that any remedies related to such a claim in a proceeding before the Copyright Claims Board shall be limited to those available under this chapter. That means remedies of financial or monetary, whatever, will be limited as set forth in the Small Claims Act. So if you choose to pursue a 512F misrepresentation claim, you're probably limited to the $30,000 limit that we should be coming up on here in one of these upcoming damage sections. Do people typically have $30,000 in misrepresentation claims that they would need to go after somebody in small claims court? No. If you have a $30,000 misrepresentation claim, you're probably ready to go after them in real court. And I don't mean to be insulting. The small claims court is real court. I'm just being fun here with calling small claims court, little kindergarten court, and then there's big boy court. It's not an insult. The attorneys are great attorneys, and they're sure they're going to do great work. It's not against them. It's just a funny way to phrase it. I'm not trying to be disrespectful. Any counterclaim that is asserted solely against the claimant in a proceeding, pursuant to which the counterclaimant seeks damages within limitations, as long as the counterclaim arises under Section 106 or 512F, is a claim for non-infringement or a claim for misrepresentation. So any one of those, a Section 106 claim, a 512F claim, a claim for non-infringement under paragraph 2, or a claim for misrepresentation under paragraph 3, or arises under an agreement, so some sort of contract that applies to the copyright applies as well here. A legal or equitable defense under this title would be allowed. A single claim or multiple claims by one or more claimants against one or more respondents, but only if all claims asserted in any one proceeding arise out of the same allegedly infringing activity or continuous course of infringing activity and do not result in the recovery of such claim or claims for damages that exceed the limitations under this act. The following claims are not subject to determination by the Copyright Claims Board. A counterclaim or claim that is not a permissible claim under Section C, a claim or counterclaim that has been finally adjudicated by a court, a claim or counterclaim that is against a federal or state government entity, so you can't use this to assert a claim against the government, a claim or counterclaim asserted against the United States. Same thing. Permissible remedies is Section E here. This is one of the things we wanted to get to. Monetary damages, actual damages, profits, or statutory damages are allowed. Actual damages in accordance with Section 504B, statutory damages up to $15,000 per work infringed. If the works are timely registered, with respect to works that are not timely registered but are eligible for an award of statutory damages, $7,500 per work with a maximum of $15,000 total. The Copyright Claims Board may not make any finding or consider whether the infringement was considered willfully. So you cannot consider a willful, whether or not the infringement was committed willfully. Why does this matter? Because usually you multiply by 3 for willful infringement. Sometimes it's more than 3. Sometimes it's 4. We saw in the Oberlin College case, they multiplied by 4. Instead, you multiply by 3 in most cases. So the copyright small claims defendants would not be subject to additional damages for a willful act. That's really important. I think this might actually merit some serious consideration because there are some serious concessions in here to allow 512F claims, to allow any related misrepresentation claim for breach of contract or something, for if you had a license or a contract, and eliminating the willful multiplier, basically. The Copyright Small Claims Board may consider as an additional factor in awarding statutory damages whether the infringer has agreed to cease or mitigate the infringing activity. Normally, this is not considered, so that's also really important. Normally, the judge does not consider whether the infringer took any mitigating steps to cease the infringement because copyright is usually a strict liability offense. You either did it or didn't. It doesn't matter what you meant or whether you meant to stop or whether you stopped it when you were caught, because in statutory damages are normally just award, whatever the judge awards for that kind of infringement, whatever cases award for that kind of infringement. For example, BitTorrent-based copyright infringement is about $2,250 per infringement, but that's because it's got multiplied by 3. So now BitTorrent-based copyright infringement brought under the Case Act would probably be $750 per infringement. Still a very high number. You don't need many infringements before you're into the tens, 20s, 30s, thousands of dollars. And trust me when I tell you that there are infringers out there who are infringing in the dozens to hundreds of infringements, even against some of the major players like Malibu Media and Strike 3 Holdings right now. There's going to be I think there's going to be a Bloomberg article coming out about Malibu Media and Strike 3 Holdings this week, and I think you're going to really enjoy it. I'll share it with you on my channel and on Lawful Masses and all that. It's not written by me, but I got interviewed pretty heavily this week for it, and hopefully a really cool article comes out. You'll be able to read all about that. With respect to a claim or counterclaim for infringement, at any time before final determination, a claimant or counterclaimant may elect to pursue actual damages or statutory damages, or simply not to pursue damages. Damages for other claims, such as 512F, shall be brought subject to the limitations of paragraph D. So a limitation on total monetary recovery for a 512F claim in any single proceeding may not exceed the sum of $30,000 exclusive of attorney's fees that may be awarded later under section 1506Y. Oh, we got to letter Y in section 1506. Great. Let's see here. So once again, I really want to make sure this is clear. Notwithstanding other provisions of law, a party that pursues any one or more claims. So this is a limitation on not just on 512F claims, because I kind of mucked those together. So the 512F claims are subject to the limitations of paragraph D, but all claims are subject to this $30,000 limit. Ding, ding, ding. Everybody pay attention. That is $30,000 limit total for any total claim brought in copyright small claims court under the Case Act. You can agree to cease certain activities. The Copyright Small Claims Board shall include a requirement to cease conduct if so determined. The party agrees to cease activity that's found to be infringing, to cease sending takedown notices if that's what they were doing, and to agree to that. They're allowed to agree to that as part of the thing. Attorney's fees and costs, except in the case of bad faith, the parties shall bear their own attorney's fees and costs. Also very important, except as provided for bad faith conduct, the parties bear their own costs. So only if there was bad faith conduct do you get your money back from the bad faith party. If you're the bad faith party, they're going to get their money back from you. Parties to a proceeding may be found joint and severally liable if all parties and relevant claims and counterclaims arise under the same activity. That basically means that everybody's liable for the total amount. Not that the plaintiff can recover more than the total amount, but rather if Kaylee and I here are jointly and severally liable for something, and I have assets to pay for it and she doesn't, well, they can come after my assets, get all their money, and maybe I can go after Kaylee myself for not having paid her half of the judgment or whatever. But the plaintiff, they don't care. They just want to get their money back. So they get their money back from one of us, and then it's up to us to figure out the rest. The Register of Copyrights may establish regulations relating to the permitted number of proceedings each year brought by the same claimant under this chapter. That's another super important thing that says that a copyright plaintiff can be limited to the number of claims they bring. So does that mean that Strike 3 Holdings can bring 3,000 cases in a year? Maybe not. We don't know yet. The law is not the law, and the Register of Copyrights hasn't established a number. Maybe they'll say 3,000 cases is fine. It could happen. But it's nice that that's in here, and you should know that. There is a registration requirement. A claim or counterclaim alleging infringement of an exclusive right may not be asserted unless the legal or beneficial owner of the copyright has first delivered a completed application to the Copyright Office, and a registration certificate has either been issued or has not been refused. read that carefully. That's also really cool. That means that you can get into copyright small claims court before you can get into big boy court, because you have to have a valid registration that has been granted by the Copyright Office with a valid number and all that before you can go to district court. But
Wait. So in the other case, when it went to big boy court and then the judge said, no, you can't proceed because you don't have a registration number.
Yeah.
So if you go into the small claims court and only have started the registration process and don't have the number, and the other person says, no, I want to go to big boy court, does that mean that your case dies?
Probably at that time, yeah. Yeah, that would probably be, there's a good loophole, good catch there, Tactical. Yeah, if you get one of these things and the copyright is being applied for, you could delay the whole thing by simply refusing to participate in the Voluntary Case Act evaluation and adjudication of the thing, and instead requiring the opposing party to wait for their application to be granted, and then you would have to file, or they would have to file in district court. What does that mean? Does that mean if I am a copyright plaintiff and I tried to adjudicate copyright infringement with you in small claims court and you refused so that you could delay my adjudication of the thing, do you really think that deters me, or do you think that emboldens me? I might just be emboldened to go after you for every last cent rather than adjudicating the thing in small claims court. So you might tread carefully there. So that's pretty remarkable that you can get at copyright small claims court before you have a registration certificate granted by the Copyright Office. And then it says, notwithstanding any provision of law, a claimant or counterclaimant in a proceeding before the board shall be eligible to recover actual damages and profits or statutory damages if requirements of subsection A have been met, except the Copyright Small Claims Board may not render a determination in the proceeding until a registration certificate has been issued. So they're getting around that by simply waiting, like we should have, like we saw we wanted to do in the Gigi Hadid case, is have a stay of the proceedings until the thing's registered. That's allowed here. That's not allowed in district court, according to the Gigi Hadid case. So the registration certificate has to be issued, and the parties to the proceeding have been provided an opportunity to address any dispute over the registration. If the proceeding may not proceed further because the registration certificate for the work is pending, the proceeding shall be held in abeyance pending submission of the certificate to the Copyright Small Claims Board, except that if the proceeding is held in abeyance for more than 1 year, the Copyright Claims Board may, upon providing written notice and 30 days for the parties to respond, dismiss the proceeding without prejudice. So no claims open for more than a year and 30 days, really, with opportunity to respond and all that. If the Copyright Small Claims Board receives no notice that registration with respect to the work has been refused, the proceeding shall be dismissed without prejudice. If a case in which registration certificate shows that registration with respect to a work was issued not later than 5 years after the date of the first publication of the work, the presumption under Section 410C shall apply in a proceeding before the Copyright Small Claims Board, in addition to relevant principles of law under this title. What the heck is that? Let's go over and look at 410C, because I honestly haven't looked at 410C in a while. In any judicial proceedings, a certificate of registration made before or within 5 years after the publication of the work shall constitute prima facie evidence of the validity of the copyright and the facts stated on the certificate. The evidentiary weight to be accorded to the certificate of registration made thereafter shall be within the discretion of the court. So let's read this carefully. In any proceeding, the certificate of registration made before 5 years after the first publication or within 5 years after the first publication shall constitute prima facie evidence, which is the basic case, the basic elements of a case, shall constitute the basic evidence of the validity of a copyright. So if you have registered a copyright, then judges will assume that your copyright is valid if you've done it timely within 5 years. That's what that means. In order to ensure that actions before the Copyright Claims Board proceed in a timely manner, The Register of Copyrights shall establish regulations allowing the Copyright Office to make a decision on an expedited basis to issue or deny copyright registrations for an unregistered work that is at issue before the board. So they might even expedite some copyright registrations so that the board can make a determination. 1506, we were looking for this one. They shall use copyright law if there appears to be conflicting precedent. The Small Claims Board shall follow the law of the federal jurisdiction in which the action could have been brought. So they'll evaluate jurisdiction and use that jurisdiction's law. They shall maintain records. They shall centralize their process. People may be represented by, this is really cool, a attorney or by a law student of parties in legal proceedings and who provides such representation on a pro bono basis. So you can get representation by a law student on a pro bono basis if such law student or school or somebody decides to provide such a thing. That's really cool. We could even try ourselves opening up a copyright small claims court legal services clinic and support our law students. Actually, this sounds like something that Lawful Masses, the charitable organization, which does not exist, we're working on it, that Lawful Masses, the future charitable organization, would love to undertake. So yours truly will either apply to be a copyright small claims officer if this passes, or we will open up a copyright small claims clinic to provide pro bono services from law students around the country who are qualified to provide said services. That sounds really cool, actually. I would really like to run that clinic.
Yeah, you could even arrange to have a special commendation or like school credit applied to the kid if the university would work with you.
Are we coming around to liking the Copyright Small Claims Act? It's a little bit of a possibility. I am concerned about the slippery slope of so much new copyright litigation. Yeah. So commencement of proceedings, they talk about how to commence a proceeding. If this passes, we'll go into great detail about all of this. Right now, I'm more concerned about the concerns. Review of claims claims have to comply. We have a dog. We have interruption by dog. You want to come up? Come here. Come on. Nope, you can't just interrupt us and then not come up. Come on. Hup. Come on. There you go. Go boy. There you go. Go boy. We have dog interruption.
That's you.
This is dog interruption.
Oh, other dog. Ilsa. Ilsa stopped over there. Ilsa.
Right now, Kotaku is asking how the courts would be funded. Right now, it's going to be funded by Congress if it passes, and it looks like there's only like 5 people right now who are being hired, and maybe more as the Register of Copyright determines. So we'll see.
I think the point here is to streamline it. So, I think they want to make the cases as short and as easy as possible, so that these copyright cases can be adjudicated quickly.
Man, I chose to become a copyright attorney at the right time, didn't I?
So right now it sounds like it is written for those situations when you have, one smaller YouTuber going after another smaller YouTuber or something like that, where the maximum damages are not going to be that big. But I think it's going to be difficult if somebody has more financial resources than the other person, because they can either bump it up to federal court and make it really expensive for the other party, and you're still going to have access to justice issues. Or if, like with the plaintiffs that you work with, where they're filing like 1,000 cases a year, then the small claims court, it could get like really overrun with just one plaintiff, given that right now they're only looking to hire, 5 people.
So here's a super important section. A claim against an online service provider for infringement by reason of storage or referral or linking, or a claim for section B, C, or D, which is the transit, the safe harbor provisions of 512, shall be considered non-compliant with the Case Act unless the claimant affirms in a statement, so like an affidavit, that the service provider was previously notified and the service provider failed to respond or disable access, etc. So it preserves the safe harbor provision for providers. Let's see, upon the filing of a counterclaim, it shall be reviewed by a claims attorney to ensure compliance as well. Unsuitable claims can be dismissed. They'll provide for service and notice and all that. We're really skimming through this at this point because this is not the final text, or what most likely will not be the final text of the act. And we will go through it in detail when we have a final act that is actually passed Congress and will become law. But that's what we're looking at here. Discovery. Discovery in a proceeding shall be limited to the production of relevant information and documents, written interrogatories, written requests for admission. That means that it seems to mean no depositions, but that effectively a deposition would be accomplished through written questions and answers. Same effect, same penalty of perjury applies and all that. Same standard of affidavit and all that, but it is now written questions and answers instead of spoken deposition, which is a real hassle, actually. It's just a total hassle to have to do all of that. And you have to get a court reporter, and it's really expensive. It's $1,000 to $2,000 easily for a day-long deposition. The Copyright Claims Board may approve additional discovery as needed and as requested by the parties and then approved. May issue a protective order. May consider the following types of evidence: documentary, non-testimonial evidence, and testimonial evidence submitted under penalty of perjury in written form or in accordance with a hearing. The Copyright Claims Board may hold a hearing. It may be attended by not fewer than 2 officers. May be recorded or transcribed as deemed necessary by the board. You may voluntarily dismiss a claimant or counterclaimant may dismiss voluntarily. And it appears there's some kind of class action right before the board as well. At any time, the parties may settle. They may request a conference with an officer for the purposes of settlement, and they may submit an agreement providing for dismissal and settlement of some or all the claims or counterclaims. They may make factual determinations, which we can go over that in detail if it actually passes. There's things about service of process, about bad faith conduct, and if there's bad faith conduct, the claims board shall award reasonable attorney's fees and costs not more than $5,000, except that a pro se party shall not be awarded more than $2,500, and in extraordinary circumstances where there's a pattern of bad faith, the claims board may award costs in excess of the limitations above.
They mentioned protective orders, being able to do that. Do you think have they mentioned TROs or a preliminary or
yes?
Or
yes, there was something above. There was something in there with preliminary injunctions and permanent injunctions. So that should be effectively the same thing as a TRO. I didn't see TRO, but it's effectively the same thing. A TRO just has a shorter limitation than a preliminary injunction.
Yeah.
If the board finds that on more than one occasion within 12 months, a party pursued a claim or defense or counterclaim before the Copyright Claims Board for a harassing or improper purpose without a reasonable basis, so an abusive or frivolous plaintiff, the party shall be barred from initiating a claim for a period of 12 months. So you can be banned from the Copyright Small Claims Board for abusive filings. The Register of Copyrights may establish regulations to provide for consideration and determination of smaller claims where total damages do not exceed $5,000, exclusive of attorney's fees and costs. And let's see, they talk about the effect of a proceeding. I'm assuming this shall not preclude litigation or relitigation between the same or different parties before any court or tribunal of the same or similar issues. A determination of ownership of a copyrighted work shall not be relied upon, shall not have any preclusive effect in any other action. So the Copyright Small Claims Board is your lowest court, and any other court action supersedes or overrides the Copyright Small Claims Court's decisions. Except as permitted under this section and 1508, any determination may not be cited or relied upon as precedent either. Class actions are not affected. A proceeding before the Claims Board shall not have any effect on a class action proceeding in the district court. Any party to an active proceeding before the claims board who receives notice of a pending class action shall either opt out of the class action or seek dismissal before the claims board. A claim or counterclaim for 512G seeks to order to restrain a subscriber from engaging in infringing activity can be filed if notice of the commencement of the Copyright Claims Board proceeding is provided by the claimant to the service provider's designated agent before the service provider replaces the material and the claim brought alleges infringement of the material identified. Okay, whatever. The failure or inability to assert a counterclaim shall not preclude further assertion of that counterclaim before the Copyright Small Claims Board. So in other words, you don't lose the right to go before the Small Claims Board just because you didn't assert a counterclaim. In any proceeding in which a party has failed to pay damages or failed to comply with the awarded relief, they can seek said relief within 1 year from a district court, any appropriate district court, for an order confirming the relief awarded, and then that judgment can be further visited upon a defendant through the normal procedures. Usually that means it gets visited against you at your county level and the sheriff comes to your property, inventories your property, or a subpoena goes to your local banks looking for your bank account. And if you've got money in the bank or you've got property, the sheriff can seize the property or the bank can seize the money and transfer it to the person who has the judgment. All this has to be done officially through court procedure, but it's not that hard to do. And there are attorneys that specialize in it. Not allowed to say the word specialize, but you know what I mean. Let's see, here's more procedures and applications and other things that I don't really think we really need to go over today.
There's an interesting question in chat.
Yes.
So, in the text, it says both parties have to agree to the small claims court thing. Could that be something that is contracted? So if you are, say, working for a company as a work for hire or whatever, and you say any copyright claims between us has to be adjudicated here. Okay.
YouTube or Google could very easily put into their policies by using our website or by clicking agree, you agree to your choice of venue as San Francisco, California, and a copyright small claims court as the court system to adjudicate the claim. You could definitely be bound to agree to copyright small claims court in a end user license agreement or other contract between the parties. 100%. Kotaku asks if they could garnish wages. Yes, garnishing wages is a state law, and that does vary from state to state. I believe Pennsylvania, where I'm at, does have a garnishing wages law. Some states' laws are different, so how they can get to your income or assets will vary from state to state. That is not a federal thing. The federal judgment doesn't actually get directly visited upon you. The federal judgment gets converted to a county court judgment, a common pleas court judgment, and then that common pleas court judgment gets visited upon you by the sheriff or executed or levied upon your property, and then from there you either cough up the money. You might remember the famous case that everybody loves to read about where I think it was a Bank of America branch or some bank didn't pay their judgment, and the sheriff came and started taking furniture out of the bank branch until the bank manager came running out with permission to cut a cashier's check for the amount, and the furniture was promptly returned and the bank business was restored to full operation. But that's a true story, absolutely 100% true story. So what do we think of the Case Act? I saw some things in there that I like, and I feel a little bit bad because I advocate for the little guy, and it's hard for me to see the outrage at the Case Act, which is going to destroy copyright ownership for the little guy, in theory. And then we actually read through it and look, there are some things in here for the little guy that a person can defend themselves fairly easily with written questions and answers. You don't have to attend a deposition, that you can assert your 512F misrepresentation claims, that you basically go through an expedited and easier process. This does look to allow you to pursue up to $30,000 in damages total, $15,000 per infringement, and there's some other limitations in there. And trust me, the very, very basic levels of infringement are not going to be $15,000 and $30,000 damages. BitTorrent copyright infringement is probably going to be $750 per infringement. Gigi Hadid posting exclusive Lee's photograph on Instagram is probably going to be $750 per infringement. So I don't expect to see massive judgments for very, very basic copyright infringement. So I don't know that I don't think that this is necessarily automatically a bad thing. This would allow a lot of YouTube creators who get these frivolous 512 claims, these DMCA takedown notices, and their misrepresentations under 512F. It would allow those people to pursue their damages, including statutory damages. So that's interesting, and I think we should consider that, and maybe throw our weight behind the Case Act if you agree, only if you agree, that this would be a good thing for our country and our copyright law. So let me know what you think in the comments below. All right, so that is our show, everyone. Thank you for joining me. I am Leonard French, your favorite copyright attorney, and joining me in the studio today has been Kaylee, as well as Tactical and Brandon in the virtual studio. Thank you to our supporters on Patreon and Sponsors. At the $500 level, we have a $500 supporter, Joshua Davis from TandaPay, in the month of July. We'll be going over his social insurance program that is dependent, it appears, to be using the blockchain technology for some actual functional purpose, which is really cool. I'm looking forward to seeing that. Thank you to our $50 plus supporters in July: John Steele, Gavin Barnard, Kyle Mudrak, Eevi, Michael Pearce, Richard Fournier, Spirit Bear, Jan Negrey, Daniel Perez, and Snorre Wisotzky. And thank you to the $5 plus supporters who are scrolling on the LED panel behind me and in the description with the $50 plus supporters and the $500 supporter as well. So I'll have some dog video for you here for the outro, of course. Actually, here is a dog. Here is the dog.
Shark.
So nowadays we do this. We've changed it a little bit. Brandon does does the major edit, and then I do the final edit, so I can throw any last minute things in there that I want. And it seems to be working out really well that way. And we'll probably go back to a less intensive way of doing it, but this is working out really well. And Brandon had that effect, or that animation at the end, and we actually missed it when it wasn't included in one of the later projects, or I think I was working on something and didn't have it, and I was like, oh, that would have been nice to include, but it was late and I just didn't include it. Okay, so that's our show. Love you all. Have a good Sunday and a good week, and I'll see you in the videos that drop. I'm Leonard French, your favorite copyright attorney, and I think I'm doing it again. I'm doing it and I just can't say goodbye.
Bye.
Bye.
Bye.